Part 3. Soon after landing, I found myself deep in conversation with Toshiharu Okubo, an official of Marubeni, the trading company that was serving as Lockheed's representative and go-between in the already ongoing TriStar negotiations. Beaming, Okubo reviewed Marubeni's efforts on behalf of TriStar, then gave me the good news that tomorrow at 7:30 a.m. we are seeing Prime Minister Tanaka about the matter. I was quite impressed with and encouraged by the power of Marubeni, power that made it possible to make an appointment with the Prime Minister only 24 hours after I had asked Marubeni to set up such a meeting. Then came an unexpected development. When we began to discuss in detail how to bring about the sale of TriStar, Okubo suddenly suggested that I make a pledge to pay money for a major favor like this. Though the proposal did not appall and outrage me, I was nonetheless quite astonished that the question of money had been brought up so abruptly, especially since in broaching, meaning mentioning the idea of Okubo, mentioned the name of the Prime Minister's secretary, Toshio Inamoto. Inamoto. How much money do we have to pledge? I asked. The going rate when asking for a major favor is usually 500 million yen. I was now faced with the problem of whether to make a payment to Japanese highest government office. Sensing my hesitation, Okubo reiterated, if you wish to be successful in selling the aircraft, you would do well to pledge 500 million yen. Lockheed made this payment and similar payments. Did it act morally in making these payments? Did it violate the ethical principles dominant in the United States or Japan? Did the fact that U.S. law did not make the payments unlawful at the time they were made justify them? I just want to see if we can look, let's say, 1972. I wonder what the U.S. dollar equivalent of 500 million yen was. How much, I don't even know how to ask it. In 1972, how many dollars was 500 million yen worth? How many dollars did 500 million yen equal in 1972? So it looks like that would have been around $300 million, which I know in 1972 was crazy. All right, I was just curious. Nosy. Back to the book. Concept summary. Theories of ethics. This is a little chart that they have on page 10 that just touches everything that we covered. Ethical fundamentalism, utilitarianism, Kantian ethics, Rawls' social justice theory, ethical relativism. All right, so moving on to the social responsibility of business. Business does not operate in a vacuum. Decisions made by businesses have far-reaching effects on society. In the past, many business decisions were made solely on the basis of a cost-benefit analysis and how it affected the bottom line. Such decisions, however, often cause negative externalities to others. For example, the dumping of hazardous waste from a manufacturing plant into a river affects homeowners, farmers, and others who use the river's waters. Thus, corporations are considered to owe some degree of social responsibility for their actions. The theories of social responsibility of businesses are discussed in the following pages. And I'm sure in your area, just like in mine, there have been businesses who have dumped chemicals into the drainage system, or in one case here, into the Puget Sound. And, that stuff affects people for years and years to come. But anyway, moving on to maximizing profits. The traditional view of the social responsibility of business is that business should maximize profits for shareholders. This view, which dominated business and the law during the 19th century, holds that the interests of other constituencies, example, employees, suppliers, residents of the communities in which businesses are located, are not important in and of themselves. In the famous case of Dodge versus Ford Motor Company, a shareholder sued the car company when Henry Ford introduced a plan to reduce the price of cars so that more people would be put to work and more people could own cars. The shareholders alleged that such a plan was illegal because it would not increase dividends. Mr. Ford testified, "My ambition is to employ still more men to spread the benefits of this industrial system to the greatest number, to help them build up their lives and their homes." The court sided with the shareholders and stated that Mr. Ford's testimony creates the impression that he thinks the Ford Motor Company has made too much money, has had too large profits, and that although large profits might still be earned, a sharing of them with the public by reducing the price of the output of the company ought to be undertaken. There should be no confusion of the duties which Mr. Ford conceives that he and the stockholders owe to the general public, and the duties which in law he and his co-directors owe to protesting minority stockholders. A business corporation is organized and carried on primarily for the profit of the stockholders. The powers of the directors are to be employed for that end. The discretion of directors is to be exercised in the choice of means to attain that end, and does not extend to a change in the end itself, to the reduction of profits, or to the non-distribution of profits among stockholders in order to devote them to other purposes. Side note, I think that this is a great example to let us know that we as investors are protected by the law, and that the law wants to make sure that as investors we receive the most profit on our monthly dividend statements that we should be receiving in the mail, not online. Hint, hint. All right, Milton Friedman, who won the Nobel Prize in Economics when he taught at the University of Chicago, is a current advocate of this theory. Friedman asserts that in a free society, there is one and only social responsibility of business: to use its resources and engage in activities designed to increase its profits as long as it stays within the rules of the game, which is to say, engages in open and free competition without deception and fraud. Moral minimum. Some proponents of corporate social responsibility argue that a corporation's duty is to make a profit while avoiding harm to others. This theory of social responsibility is called the moral minimum. Under this theory, as long as business corrects the social injury it causes, it has met its duty of social responsibility. For example, if a corporation pollutes the waters but compensates those whom it injures, it has met its moral minimum duty of social responsibility. The legislative and judicial branches of government have established laws that enforce the moral minimum of social responsibility on corporations. For example, occupational safety laws establish minimum safety standards for protecting employees from injuries in the workplace. Consumer protection laws establish safety requirements for products and other manufacturers and sellers liable for injuries caused by defective products. Other laws establish similar minimum standards of conduct for businesses in other areas. Stakeholder interests. Businesses have relationships with all sorts of people other than its stockholders. This includes its employees, suppliers, customers, creditors, and the local community. Under the stakeholder interest theory of social responsibility, a corporation must consider the effects its actions have on these stakeholders. For example, a corporation would violate the stakeholder interest theory if it viewed employees solely as a means of maximizing stockholder wealth. This theory is criticized because it is difficult to harmonize the conflicting interests of stakeholders. For example, in deciding whether to close a plant, certain stakeholders may benefit, example, stockholders and creditors, while other stakeholders may not, example, current employees in the local community. And isn't it interesting how we are continuing to see that we are encouraged to be investors over employees? Hint, hint. Corporate citizenship. The corporate citizenship theory of social responsibility argues that business has a responsibility to do good. That is, business is responsible for helping to solve social problems that it did little, if anything, to cause. For example, under this theory, corporations owe a duty to subsidize schools and help educate children. Excuse me, y'all, my stomach is hungry or grumbling. This theory contends that corporations owe a duty to promote the same social goods as do individual members of society. Proponents of the do-good theory argue that corporations owe a debt to society to make it a better place, and that this duty arises because of the social power bestowed on them. Hint, hint. Proponents of the do-good theory argue that corporations owe a debt to society to make it a better place, and that this duty arises because of the social power bestowed on them. And what have we been taught are the powers and the duties of the banks? And forgive me if I get this wrong, but I think that's in 12 USC 1431. Is that right? That's 12 USC 1431, also known as Title 12, Chapter 11, Section 1431. It's a section of the U.S. Code that outlines the powers and duties of the banks. And I'm not going to elaborate on that at this time. Mensa teaches that, and you can Google it. But as we see here, the do-good theory argues that corporations owe a debt to society to make it a better place, and that this duty arises because of the social power bestowed on them. If you want to learn more about that, see 12 USC 1431 for the powers and the duties of the banks. All right, a major criticism of this theory is that the duty of a corporation to do good cannot be expanded beyond certain limits. There is always some social problem that needs to be addressed, and corporate funds are limited. Are they really? Further, if this theory was taken to its maximum limit, potential shareholders might be reluctant to invest in corporations. For more information on that, I encourage you to watch Path to Freedom, TDA 2.0 question and answer.